Hello everyone, welcome to our channel Preston Educational Academy. Today we will be learning about business law and ethics. It is an important subject included in the syllabus of BBA and BCom. Now let's start with the subject. Now coming to the introduction to business law. Let us know what is business law. All the laws which pertain to how, what and why of how businesses are legally allowed to and supposed to function. Means here the business laws provide us the framework for how the businesses are legally allowed to function and how are they supposed to function. Business laws include contract laws, manufacturing and sales laws, and also hiring practices and ethics. So business laws include contract laws. Here in today's class we will be learning about the Indian Contract Act. So the Indian Contract is the act coming from contract laws. Then we have Sales of Goods Act, which is coming from sales laws, and hiring practices and ethics, that is coming from Consumer Protection Act. So that these all things are included in the business law. Coming to the Indian Contract Act 1872, it is based on English common law. So here we have the origin from the English common law, and it provides a framework for understanding and enforcing different contracts. So here the Indian Contract Act is explaining us, providing us with the framework for understanding and enforcing different contracts like valid, void or voidable. Means they are different types of contracts in the Indian Contract Act, which we will learn in today's class. So to understand and enforce them, the Indian Contract Act is providing us the framework. Before moving on to the types of contracts, let us learn about very important key terms, that is difference between agreement and contract. Now what is an agreement? An agreement is where one party to offer is known as offerer and the other party to accept the offer known as offeree. Means here if one party is there, A wants to sell his car to B. So here A becomes an offerer and B becomes offeree. So here B is the offeree, means who is accepting the offer. So an agreement is equal to offer plus acceptance. But it can be enforceable or it may not be enforceable. But what is a contract? An agreement that can be enforceable by law becomes a contract. Means here enforceability means whenever you have any problem or whenever you feel like suing the person for breaching the contract or not performing the contract, the law will get it enforceable. So here the contract is equal to agreement plus enforceability. Now let us move on with the important concept, types of contracts. We will learn about the types of contract in today's class in detail. So based on validity, based on formation and based on performance. The contracts are divided on three classifications. Each classification is further divided into the different types of contracts. So the first one is based on validity. So based on validity, we have three types of contracts, that is valid contract, void contract and voidable contracts. What is valid contract? A contract that can be enforceable in the court of law. Means There are few features that should be satisfied for a contract to be valid. So that features, if they are satisfied, it should have a lawful object, the consideration should be there should be some free consent. All that features we will learn in the further classes. So all those features, if they are valid, if they are satisfied, then the contract becomes valid contract. In that case, it can be enforceable in the court of law. Whereas void contract is not binding in the court of law, means it cannot be enforceable. Means either it can be valid while the time of making the contract but becomes void due to the circumstances, or it can be void from the initial stage of entering into a contract. So the simply remembering it, that the contracts that are not enforceable by the law becomes void contracts, whereas the voidable contracts is enforceable by the law only at the option of one or more parties involved in the contract. Means here, if there is no free consent, if there is any physical harm or mental influence given, the coercion or undue influence, these are the terms we will learn in detail of the each and every term what we are discussing. So coercion is a physical harm, undue influence is a moral influence using the possession, dominant position. So like that, if any of the person is getting the consent using these not a free consent but using the coercion or undue influence, so the one of the party can get it enforceable by the law. Moving on to the second, formation based on the formation. So the contracts are classified into four types based on the formation. They are expressed contracts, implied contracts, quasi contracts, and e-contracts. What are expressed contracts? With the name itself, you can understand that the contract that have or expresses the terms and conditions either orally or in written becomes the express contracts. Means if suppose A wants to join B, if A wants to join in B's school, so in that case, the agreement becomes express. There is an express contract expressing the terms and conditions of a teacher, what would the subjects be there, what would her salary be, all the terms and conditions are expressed in the contract. Whereas for implied contract, the code or conduct not in the written form but implied to the acceptor by the promisor. Means here, the A and B have entered into an express contract, but as a duty of the teacher, it is implied that she have to maintain the discipline in the class, she have to take care of the students safety and security, she has to give the report cards, she have to correct the papers, everything. So here those things are not exactly expressed in the contract, but they are implied on the teacher as her part of responsibility and duties. So such contracts who are based on the conduct or act of the party becomes the implied contracts. Coming to the quasi contracts. These contracts are not intentionally formed but imposed or coming out of humanitarian emotions. Means if suppose you are walking on the road and you find that someone have met with an accident, you will simply go and help them to get up from there and relax aside, give them some water and all. So here you and the person have not expressly or impliedly entered into any contract. It was out of your humanitarian emotions, that is sympathy and empathy, that you have helped the person from getting up and sitting aside. So those are quasi contracts because even they are valid in the eyes of law. Coming to the e-contracts, they are formulated online in the form of soft copies. We see that post COVID we are able to find many of the online courses. So all these you have signing them with soft copies in the system or desktop. So here the terms and conditions what are expressly mentioned, and the fees what you are paying, everything, the offer and acceptance are through the online soft copies of the agreement. So such contracts are known as e-contracts. Now the last one, basis of the performance. Based on the performance, they are classified into four types: executed contract, executory contracts, partly executed contracts, and partly executory contracts. Executed contracts means the obligations have been already performed and nothing is left to be performed. Means here, if A is willing to sell his car to B for 1 lakh, here B have accepted the offer and he had paid the money to A and A had delivered his car to B. Means here both the parties have performed their part of obligations and nothing is left to be performed. So such contracts are called executed contracts. Executory contracts are contracts in which the parties are still left to perform their part of obligation. If we see the same example, instead of B paying the amount and A delivering the car, we say that they have decided a particular date to execute the contract. So in that case, the offer had been made in present, the acceptance had been given in present, but the execution is taking place in future on a particular date. So here it means that they are still pending to perform their part of obligation. So here it becomes executory contract. Partly executed or unilateral contract means one party. Uni means one. So here it means that one party have completed his or own part of obligation and the other party is yet to perform their part of obligation. If again we see the same example, if A and B entered into contract to buy and sell the car, A offered B, B accepted it, and B had paid the amount to A, but A have not yet delivered the car. A is still pending to deliver the car, but whereas B have completed his part of obligation. So in that case, it is called as partly executed or unilateral. Means here B have completed his part of obligation and A is still remaining to perform his part of obligation. Coming to the partly executory, same thing here. I will just off the video so that you can see the exact lines of it. Yes. When either of the parties in the contract have completed some part of the obligation and still remaining to perform the other part of obligation. So here we take again the same example. A offers B, B accepts the to buy the car. So here we have paid some amount. Suppose the car was to be sold for 1 lakh. If the car was to be sold for 1 lakh. So here B had paid 50,000 and the 50,000 is still pending. And A is yet to deliver the car. He have not yet delivered the car. Means both the parties have some part of obligation, they have performed some part of obligation and both are remaining to perform the remaining part in the future. So you bilateral means both the parties are still pending. So this becomes partly executory or bilateral contracts. With this we are. So this was about the types of contracts. It is a very important basic concept through which you can understand the further B law concepts. So please watch the videos if you feel needed once or twice, so that you are getting clarity about the concept. You will be able to quote good examples using the concept clarity, and you can make your own notes using the PDF available to you in the video. So thank you. Like, share and subscribe my channel.